Federal WARN. Layoff laws and state layoff notice requirements. Typically, there are neither federal or state laws that require employers to provide advance notice to employees before they are laid off. However, there are some exceptions. The most common layoff advance notice law is the Federal Worker Adjustment and Retraining Notification Act, WARN Act. It requires employers to provide employees advance notice to its workforce who will be impacted by a mass layoff due to a reduction in force, plant relocation, or plant closure. Most states do not have their own mass layoff notice laws, but instead comply with the federal WARN requirements through the U.S. Department of Labor's Rapid Response Program. In this article, the federal WARN layoff laws will be discussed and how it impacts state mass layoff requirements. The federal government has a notice requirement law that requires an employer to provide its employees with 60 days notice when it plans to go out of business or lay off a large number of them. The law is called the Worker Adjustment and Retraining Notification Act, WARN Act. What does the federal WARN law require? Generally, WARN covers employers with 100 or more full-time employees, not including employees who have worked less than 6 months in the last 12 months, and employees who work an average of less than 20 hours a week. Employers must provide the WARN notice to all employees, including managers, supervisors, and permanent and temporary employees. The notice may be provided by a reasonable method of delivery. An employer must provide the required notice to full and part-time employees when it closes a plant or effectuates a mass layoff. The number of affected workers is the total number laid off during a 30-day, or in some cases 90-day period. A plant closing includes the closing of a facility for more than 6 months, the shutdown of an operating unit for more than 6 months, or when 50 or more employees are laid off during any 30-day period at a single location. A mass layoff occurs when a layoff, lasting at least 6 months, affects either 500 or more workers or at least 33% of the workforce when the layoff affects between 50 to 499 employees. What are the penalties for violating the WARN Act? Employers that fail to properly notify employees of a plant closing or mass layoff may be subject to several different penalties. The employer's liability and penalties include up to 60 days' worth of back pay wages, up to $500 civil penalty for each day of the violation for failing to provide notice to the local government as required by WARN. Courts can award reasonable attorney's fees to the prevailing party. Does the WARN Act provide any exceptions to the notice requirements? The federal WARN law does provide a few narrow exceptions to the 60-day notice requirement. These exceptions, which frequently arise when bankruptcy is an issue, include if there are unforeseeable business circumstances. The business is a faltering company, which means that giving advance notice may ruin the company's chance of saving its business from going out of business. If there is a natural disaster, state WARN laws. Most states do not have their own layoff notice laws, but do operate rapid response offices that coordinate with the U.S. Department of Labor's State Dislocated Worker Unit. 7 states, California, Illinois, Maryland, New York, New Jersey, Tennessee, and Wisconsin, have enacted layoff notice laws similar to the WARN Act, often referred to as mini-WARN laws. For each state's WARN requirements, visit our website www.employmentlawhandbook.com. Other layoffs. Beyond mass layoffs and plant closings, federal law does not provide any notice protections to employees. Moreover, because most employers are governed by at-will laws in all states but Montana, employers are only required to give employees prior notice of a layoff if there is an individual employment agreement or collective bargaining agreement. However, some states have laws that provide employees some layoff protection regarding their final paycheck and the payment of accrued leave benefits, such as vacation leave, paid time off, and sick leave. Information about individual states that require businesses to provide employees specific layoff protections is available at www.employmentlawhandbook.com. Healthcare benefits and layoffs. Under the Consolidated Omnibus Budget Reconciliation Act, COBRA, employees whose employers provided health benefits and who are laid off are protected. COBRA provides laid-off employees an opportunity to retain the health benefits provided by their employer for a certain amount of time after the layoff. However, although employees may be able to retain the health insurance benefit, they will be required to pay for the full amount of the premium. The employer would not be required to continue to pay their portion of the premium if that was a benefit provided to the employee when they were employed.